Good morning, Mr. Nemsen.
Morning, Your Honors. Paul Nemser for Waste Management of Massachusetts. This case involves municipal trash hauling contracts that are subject to the Massachusetts prevailing wage laws, which are general laws, Chapter 149, Sections 26 through 27H, and the one in particular that applies here is Section 27F, which relates to contracts involving use of motor vehicles.
The case, what is before us here, precisely?
There is
all of the judge's decisions below, or just the two questions that he poses? What is before us?
Our position, Your Honor, is that there's only one question before you at this point. The only question which has been briefed is the issue whether the judge correctly entered summary judgment for plaintiffs as to the overtime law. The judge reported two questions. There was a summary judgment for waste management under the prevailing wage law, and plaintiffs chose not to brief that issue, and under this Court's authority, it should be deemed waived. So the Pineo case.
So that would apply even though this is a Rule 64 report? That's
right, Your Honor. In the Pineo case, I think I can get you a cite on that. It's 412 Mass 3135 at Note 6. Mm-hmm. The Court declined to look at an issue on a report where the issue was only briefed by the amicus and was not briefed by the party. And in that is what happened here. There are amici who briefed the issue, but it was not briefed by the plaintiffs.
I mean, we can still look at the issue if we choose to, can we?
Yes.
Okay.
Mr. Nemser, just a factual question before you start, because there's a dispute. Were any of these drivers ever actually paid $18.98 an hour?
Yes, Your Honor, they were. They were paid $18.90 an hour straight time compensation plus overtime. In waste management.
I'm just asking, $18.98 by itself for non-overtime hours. Were they ever paid that?
When they
would be paid it only in a circumstance where they also were working overtime, and then they would be paid time and a half the $18. Okay. Right. So basically, waste management pays its employees in two ways. The overtime law calls for focus on a work week. The federal overtime regulations, the FLSA regulations, are even more explicit and say that compliance with overtime should be based on the individual work week standing alone. The way waste management pays its employees is in any given week one of two ways. In most weeks, it pays the base hourly rate, the $18.50-some cents an hour rate for straight time, and then it would pay for any overtime worked, it would pay time and a half. That's compliance with the overtime regulation. It's standard procedure when an employee has a single base hourly rate. What the overtime regulation, which is 455 CMR 2.01, says is you treat that hourly rate as the regular rate, and that's exactly what waste management does. Now, there are weeks in which, in order to comply with the prevailing wage law, waste management pays not just the base hourly compensation, but an additional check, a lump sum amount.
But when you're complying with the prevailing wage law for the whole week, because it is a municipal contract, the wage rate for those employees is $21.64, isn't it not?
No, it is not, Your Honor. If I may, I'd like to separate the prevailing wage issue for a second from the overtime issue and just make clear that if you put aside the prevailing wage law, what waste management does is to comply exactly with the overtime regulation 455 CMR 2.01. In those buffer check weeks, what waste management does, the buffer check, if the employee works overtime, will have both a straight time and an overtime component. And what waste management does is it looks at all of the straight time compensation the employee received in that week, which is hourly pay plus a buffer check component, and then it calculates the hourly rate by dividing that total straight time compensation by total hours worked. That's exactly what the regulation says should be done. It says that if an employee is a salaried employee or a piecework employee or is paid any other basis other than an hourly rate, the way you do it is you add up all the straight time compensation, you divide by total hours worked.
How do other companies do it?
I don't know, Your Honor.
So if an employee worked only 40 hours,
Yes,
right?
Your Honor.
That means no overtime, correct?
Correct.
That employee was paid $21.64, the prevailing wage, correct?
Correct.
For the regular work week, the regular 40-hour work week,
Yes.
the regular 40-hour work week, he would be paid $21.64 an hour.
But the employee would be paid $18.53 an hour for the regular work week.
You call it that, but in fact, the compensation received, as required by law, would be $21.64 an hour times 40.
Well, Your
Cash
Honor,
compensation received, right?
I would agree that if no overtime is worked, in this fact pattern, the compensation required would be $21.64. But what I believe you're missing here is that the term rates of wages in the prevailing wage law has to be construed. And this Court has construed the term wages and wage rate in Chapter 149 before in a different context, in the Jancy case, which is at 421 Mass 482, and it's involving the Mass Equal Pay Act. There is no definition of wages in Chapter 149, but in the Equal Pay Act case, the Court followed a procedure which I would suggest should be followed here. First of all, the Court looked to the common meaning of the term wages and used that for wage rate, and got that from Black's Law Dictionary, and it meant any form of remuneration that's paid by an employer to an employee. Court then looked to a statute which does define wages, the Employment Security Law, Chapter 151A, Section 1. And that, too, uses that very broad formulation, any form of remuneration. The Court then looked to the Federal Equal Pay Act regulations and concluded that, yes, it, too, had that very broad understanding. That methodology is what should be used here. If you look at the term wages in the prevailing wage law, it encompasses every form of remuneration. And that's consistent with a concurrence Judge Sossman wrote in the McCarty's case a couple of years ago. She was describing the purposes of the prevailing wage law, and she said that the way you assess what's a prevailing wage is by looking at the entire compensation package. This statute expressly includes benefits. So we know that the statute expressly includes benefits and cash compensation.
Right. But
And
we're talking about the cash compensation.
exactly, Your Honor. And the cash compensation should be construed to include both straight time and overtime. People talk about the term overtime wages. It is a common usage. This Court has used it numerous times. I put the phrase overtime wages in the Westlaw database for the entire Commonwealth and got 23 hits. But this Court used it as recently as a few years ago in Swift v. AutoZone. It is a common usage because overtime pay is a form of remuneration paid by an employer to an employee. And so the two judges who have, well, let me note also, plaintiffs are suing here under a non-payment of wages statute for recovery of the overtime, Chapter 149, Section 148. And the two judges that have considered the specific issue we're talking about, which is whether overtime counts as cash payment toward the prevailing wage law, have found that it does. Judge Gantz in Charles v. Rhodes Corporation in 1999, as part of allowing a summary judgment on a prevailing wage claim, so concluded, and Judge Grabeau below in the summary judgment for waste management, which plaintiffs did not appeal.
Forgive me. I take it that that's your particular disagreement with the Attorney General's interpretation.
Well, that is a disagreement with the Attorney General's interpretation, Your Honor. Both Judge Grabeau and plaintiffs, apparently, who didn't contest Judge Grabeau's ruling on summary judgment in their briefs in favor of waste management, seem to...
But I guess that this is simplistic, I know, but I'm having trouble with the idea, all right, we count overtime as part of what prevailing wage applies to. At the end of the week, though, if somebody's worked 50 hours, what's happened to the overtime law? Nothing. They've gotten nothing.
Yes, they have, Your Honor. They got exactly the overtime on the...
Oh, in your Alice in Wonderland calculation,
Well,
yes.
it's not an Alice in Wonderland calculation, Your Honor. It is the calculation mandated by the overtime regulation. Section 2.01, second sentence, says that the way you calculate it in a week in which you have hourly pay plus something else.
But
plus
the hourly pay was the prevailing wage pay. I just can't.
No, Your Honor. The prevailing wage law does not set hourly pay does not set a particular regular rate. The prevailing wage law takes into account benefits, takes into account straight time,
Let me ask you
and
this
takes into
question.
account overtime.
If somebody worked 40 hours a week, just 40,
Yes.
would that person get a buffer check because actually the paycheck would be $18.90 and then you'd add on to get the prevailing wage total?
The
He wouldn't.
employee who works just 40 hours a week would get the 18-plus hourly wage plus would get a buffer check.
He would actually get a buffer check, or is the buffer check only when you've got the overtime problem?
No, it's when
No,
you
no,
don't
no,
have
it's
the
in any
overtime.
event.
Okay.
Yes, and at that point, there would be no overtime payable.
No, I
Now, if the
understand that.
employee also worked overtime, then you would recalculate the regular rate by adding up all the straight time compensation, divide by total number of hours worked, and that would give you the regular rate for overtime purposes. And it's important to take into account the way the federal Fair Labor Standards Act defines the term regular rate. It's instructive. The Fair Labor Standards Act defines the term regular rate to be, first of all, any form of remuneration. So it is consistent with the definition of wages that this court has used in the past to work under Chapter 149. It then excludes certain things, and it specifically excludes overtime, and it excludes benefits. So what the implication is there, clearly overtime and benefits are a form of remuneration. They are something that would ordinarily count toward wages under the prevailing wage law, but they are excluded under the definition of regular rate. And those exclusions in the federal law are incorporated by reference in the state regulation, 455 CMR 2.01. What that means is...
Finish.
What that means is wages include benefits, straight time, and overtime under the prevailing wage law. But the regular rate for overtime purposes only counts straight time. What that means is that the prevailing wage law does not set a minimum specific cash straight time hourly rate. It does not set the regular rate.
Mr. Nemsen, let me ask you
Sure.
this hypothetical, just so that I make sure to understand. If you work, you've already answered the first question, I'll just repeat it. If you work 40 hours,
Yes.
you get paid the base rate plus a buffer check, which brings it up to the 21.84, correct?
Right, on these facts.
Correct. I don't know what the hours are, but there must be a certain number of hours that if you took into account the overtime and recalculated, you would come up with exactly the same amount of 40 times 21 point whatever it is.
That's right.
Okay. So
It's usually 50 hours, Your Honor.
so let's say it's 50 hours. So that if an employee works 40 hours and an employee works exactly 50 hours, the employee that's working 50 hours is getting no more per hour for the overtime work. Is that correct?
No, that's wrong, Your Honor. The employee who works 50 hours is getting time and a half the 18. In other words, the 27, 28.
No, but the net...
there's a 50% premium.
The net result is whatever the baseline is,
Yes.
divide. So for 40 hours, if I divided it, if I took the check, the total check, and divided it by 40, I would get $21 an hour. And if I took the 50 hours and divided it by whatever I got in my check, I would get $21 an hour.
No, that's wrong, Your Honor. You get quite a bit more than $21 an hour, I think.
You would?
Well, wait.
I'm
No.
trying to figure out
It
which...
depends how many. Wait, if you work 50 hours exactly, I guess that's right. If you work 51 hours,
No, 51, no,
then
just
you would
ta-
get more.
I'm just
Why?
taking
Why
the
would you-
50, I'm just taking the point where it actually matches. So that if you take whatever check, base plus buffer or total, and you divide
Right.
it by the number of hours, you would be getting $21.68 per hour, correct?
On the 50-hour plan, yes.
And you would say, and that's all contemplated by the statute.
Well, the prevailing wage law does not exclude overtime. It includes overtime for the reasons that I've just been arguing. And the Federal Fair Labor Standards Act makes that really pretty clear. The Fair Labor Standards Act excludes overtime and benefits. The prevailing wage law, the definition of wages, includes overtime and benefits. So the prevailing wage law does not set a specific minimum hourly cash non-overtime wage rate. And if it doesn't set that, then we go back to the thing I was discussing at the very beginning, which is, does Waste Management comply with the regulation 2.01 of 455 CMR? And it does, because that is a weekly assessment. And the key is, in any given week, Waste Management complies to the letter with that provision, if you put aside the argument which the trial judge accepted, which is that the prevailing wage law changes everything.
Just one slight question. When you said if it were 51 hours, you'd be getting more per
Yes,
hour?
Your Honor.
Yes.
Why is that?
Because you would be getting paid the additional hour.
For the
So you'd be
additional
getting,
overtime.
you would be getting,
But it would be more per hour?
yes.
Yes,
Because if you took the 51 hours and divided it by the number of hours worked, you get
Right,
slightly more.
yeah, okay.
You're getting paid something like $27, $28 an hour
No.
for
And the more overtime
for the
you work-
overtime hours.
And the more overtime you work, so if you worked 60 or 70 or 80 hours, it would turn
It'd be
out.
higher still.
Sure. Thank you, Mr. Nemeth.
Thank you, Your Honor.
Mr. Ellis.
Good morning. May it please the Court. My name is Henry Ellis. I represent a class of current and former Waste Management garbage truck drivers. The drivers respectfully ask the Court to affirm the Superior Court ruling that Waste Management's wage scheme is illegal as a matter of law because it fails to pay overtime wages based on the prevailing wage law's minimum regular rate of pay.
Can I ask you, why is it that you did not, in your brief, address the first question that the court posed to us, that the trial court posed to us?
The prevailing wage claim issue?
Right.
For a number of reasons, Your Honor. As a practical matter, if the court were to rule in favor of affirming the overtime claim, then the prevailing the formula used by Waste Management serves no purpose. It will die of its own volition, if you will, because there is no basis upon which to create the formula which sets a rate below the prevailing wage rate. So
I'm not sure, I don't understand that. Let's assume we agree with you, or we agree with the judge below, that the overtime rate is the 21, in this case, 2164 times time and a half. So that's what the employee has to get paid when he or she works over the 40 hours. I take it that Waste Management could say, well, that's fine. We estimate 50 hours. We're going to adjust our base pay rate from $18.98 to $16, and it'll all wash out, right?
I don't believe that mathematical formula would work in that respect.
Why not?
Well, if the overtime law is affirmed and it says they must pay overtime based upon the prevailing wage law's minimum hourly rate.
The cash component.
The
Cash component, so
In
say
this
$32 an hour instead of 27 or something.
In this
like
case, it's $21.64 an hour.
Right, times
They
1.5.
have no option but to pay $21.64 for 40 and time and a half for the next 10 hours.
I take it you would say that you could have answered number one or number two. They simply formulations of essentially the same question.
Well, if you reach the same result, in other words, if the prevailing wage minimum
If the
hourly
answer to question one is yes, that disposes of question two, and you've gone in the other door. You've said if the answer to question two is yes, then that disposes of question one.
Yes.
And you chose to go in through the number two door.
Correct, because from my perspective, of course, the damages in this case flow solely from the overtime claim. There are no damages associated with the prevailing wage claim because the scheme that is used by Waste Management, they do in fact pay $21.64 an hour for non-overtime hours. This addresses Justice Botsford's question, which is, are they ever actually paid $18.98 an hour? And that is absolutely not true. They are not.
I have a question. I don't quite understand the relationship between those two numbers. How do you get from 2164 to 1898?
That is a mathematical manipulation designed by Waste Management predicated on their assumption that a worker works 50 hours in a week. What they do is they calculate that if you work 50 hours in a week, and they contend that you can then pay them an average rate of $21.64 for that 50 hours.
Well, I see, you explained that in your brief. Okay, I just didn't see.
So then if you, so then you,
Okay.
So they issue a buffer check initially.
Right.
If it's below 50 and above 40,
They do, yeah.
or at 40, to bring it up to the $21.64, which belies their characterization that $18.98 is the regular rate. It's an artificial, arbitrary number, and as Judge Grabow said, it has no relation.
did they actually get 2 checks?
Yes, two separate checks. On their paycheck, their regular time is calculated at $18.98 an hour. There's a separate check given to them.
And
The
the
sole
excuse me. And the $18.98 comes from where?
It's a mathematical form.
So it's an internally generated number.
Correct, based upon, they take the 2164.
Yeah, I understand. I understand.
So,
Is
so
that-
go ahead. Oh, so if I get this right then, if the prevailing wage changes to 25, that's the cash component, then that 1898 by definition is going to change.
Correct.
Yeah.
Is that a common
If you-
practice
why-
among
why
companies?
do you choose? Why did they choose 50? Do you know 50 hours?
I don't know that, Your Honor. The discovery in this case has not taken place, so in order for me to find out specifically how they came up with that, they submitted an affidavit in summary judgment proceedings that said that whether it was arbitrary or not, I'm not sure, but they
Well,
just...
wasn't it a good faith estimate as to the number of hours of overtime anticipated?
Correct.
You know, I still don't understand, and maybe I'm just confused here, but the court below ruled that for purposes of the prevailing wage law, you take the overall wages received and divide by the number of hours, and if it comes up 21 something or other, you're okay.
That's only correct for if it reaches the prevailing wage minimum rate for non-overtime hours.
Well, no, that's not what the judge ruled below, though. I mean, the judge,
You're
you're not contesting what the judge says, which is that you take the overtime hours, you take the regular hours, you add them all, you add all the total compensation, you divide by the total number of hours, and for purposes of satisfying the prevailing wage law, as long as that's more than 2164, you're all set. That's what the judge ruled below.
For non-overtime hours, Your Honor. He then said, and it's very clear in his decision, he said, but that does not excuse Waste Management's failure to pay time and a half based upon the regular rate of pay, in other words, 2164.
Sure, and so in other words, what the company says you got paid for, your clients got paid for overtime was 27 something, which is 1898 times 1.5. You say they should have gotten 32. So isn't the difference for the overtime violation $5 an hour?
It's whatever the calculation is, the difference between time and a half based on 1898 and time and a half based on 2164. Yes.
But if you won on both issues, wouldn't your recovery be a heck of a lot more than that?
Not necessarily, Your Honor, because it's if the overtime provision law, if the overtime decision is affirmed, it says that the minimum regular rate under the prevailing wage law must be the regular rate for determining overtime.
For determining overtime?
Yes.
Okay, so that's
And-
$32.
Correct.
So times,
It's $21.98 times
times 1.5,
Five, times
2164.
1.5.
whatever, $33.
As a result of this mathematical construct, were they in fact receiving $18.98 an hour regular pay?
Never.
Well, they got checks based on that.
Yes, but they got a separate check,
Yeah.
which, in fact, created...
So for
a-
IRS purposes, it's the combination.
Correct. They were paid $21.64 an hour for their non-overtime hours.
Mr. Ellis, could I ask you this? I mean, what as I understand Waste Management, they rely in large part, not entirely, on FLSA. I mean, to what extent, I mean, where does FLSA play into this?
Well, the Fair Labor Standards Act, I think, is entirely consistent with Massachusetts law. In fact, Massachusetts law
No,
is...
you say it's consistent, and they say it's not. But I mean, to what extent do I have to include the interpretation under the Fair Labor Standards Act as part of this? I mean, you're essentially looking at the two Massachusetts statutes, the prevailing wage and the overtime, and saying read those harmoniously.
Well, the Fair Labor Standards Act, of course, requires overtime. to be paid.
No. Do we even have to get involved in a discussion of the Fair Labor Standards Act?
Well, I think that the federal case law, which has treated this type of situation under the FLSA, is informative. The case of Walling versus Helmera.
No, I understand that,
Yeah.
but it's informative, but if we wrote an opinion that didn't even mention the Fair Labor Standards Act, would I be overlooking something?
I don't believe so, Your Honor. I don't believe that there's.
I mean, do I have to look to the Fair Labor Standards Act? Do I have to look as a matter of law to the Fair Labor Standards Act to inform my interpretation of the Massachusetts statute?
In terms of just guidance or specific
No.
precedents, I don't believe that that's necessary.
I can
think
be
that
guided by it, I can look to it, I can analogize to it, I can find it helpful, I can agree with your interpretation.
So a decision based only upon Massachusetts law can be accomplished in this case?
There's not some supremacy clause
No,
issue
no,
here.
no.
It's not a supremacy clause, and there's no statute said that for purposes of this Massachusetts statute, we adopt the federal standard.
No, there's no preemption issue. There's no.
Okay. I didn't think there was, but I was listening to Mr. Ellis, who was giving me a very helpful interpretation of the Fair Labor Standards Act.
This is Mr.
You know,
I mean,
Mr. Nemser.
Mr. Nemser, thank you.
The undisputed record before the court, I think, shows without any argument that the scheme devised by Waste Management not only subverts the substantive provisions of the prevailing wage and overtime laws, it also violates the very significant public policies that both laws were enacted to protect. The prevailing wage and overtime statutes create fairly basic legal obligations. With a convoluted mathematical formula, Waste Management has turned those basic obligations on their head. I mean, the scheme, it undermines the overtime law because it results in workers earning lower and lower hourly rates the more hours they work, and that creates a perverse financial incentive for Waste Management to actually increase overtime work, which makes a mockery of the public policy behind the overtime law. The overtime law, of course, the purpose of the overtime law is to give a premium to hourly workers for working more than 40 hours a week and to create a disincentive to employers when considering whether or not to require overtime. And it's intended to broaden the pool of labor, create greater financial security for workers, and to give a premium to hourly workers.
Do other employers use this approach?
I am not aware of it, Your Honor, at all.
Are there any administrative cases where this approach was involved?
Well, I was referring earlier to the Walling versus Helmera case, which in 1944 the Supreme Court addressed a very, very similar wage scheme that is at issue in this case, which involved a company. This is right after the FLSA was passed, and the company essentially used an arbitrary, artificial rate lower than the statutory rate, and then based overtime on that lower rate, strictly for the purpose of keeping wages at the pre-FLSA level. And the court dismissed that emphatically, and I'll quote just briefly from some of the language from that case.
But there are no other Massachusetts administrative cases where this issue has come up?
No. The Charles v. Rhodes case addressed these issues generally, but what was important in those cases was that the advisories issued by the Attorney General and the Mass Highway Department both clearly support the notion that the cash component of the prevailing wage rate is the regular rate for purposes of establishing overtime.
Mr. Nancy, could I ask you this question? I mean, Mr. Ellis, could I ask you this question? The federal statute was amended in 1964. I mean, Waste Management makes, if I forget about the case, if I look and the Massachusetts statute was not amended in the same way, and Waste Management's claim is the federal statute, and the language is pretty clear, says that you have to use, in essence, the cash component of the prevailing function equivalent of the prevailing wage to calculate time and a half. Makes it very explicit you have to do that. If I looked at, when was the prevailing wage?
I believe it was in the
It's before 1964,
Yes.
that's for sure.
Yes.
If I looked at the prevailing wage statute in Massachusetts and the federal prevailing wage statute before 1964, would they look the same?
I couldn't say, obviously word for word, but I think that
And is there some reason why, when the federal government decided to make absolutely clear how you calculate overtime, and the Massachusetts legislature, which has amended the statute, the Waste Management says 37 times, and we know it's been amended a lot, has never clarified, made explicit, changed the statute in the same way that the federal government
I don't believe it's significant, Your Honor, because the understanding, or at least the statutory purpose behind the prevailing wage and overtime laws would be totally negated and defeated if overtime were not calculated based upon the cash component.
I mean, I know you say that, but when I have a very similar statute and the federal government amends it, it at least suggests as a matter of statutory construction that prior to that time, that's not how you calculated overtime.
But the result, if you will, the change in the language in the FLSA doesn't change, or if you will, suggest that the statutory purpose of the Massachusetts law should be interpreted.
But you just tell me that they were the same and they have the same purpose. The federal prevailing wage statute doesn't have any purpose different from the Massachusetts one. So if they start off the same, the federal amend to essentially provide the relief that you're asking for, the Massachusetts statute is not amended. What am I to make of that?
Well, I believe that the Massachusetts legislature saw no reason or purpose to change the law because the way that the law can only be interpreted and work together with the overtime law is to...
That's not what Congress thought.
Well, Congress had a very different view at that point about, then they chose to add that specific language. But the absence of that language in the prevailing wage law, I don't believe, is determinative of reaching the conclusion that the prevailing wage law does not.
What prompted the change in the federal law?
I'm not clear on the legislative history specifically in that regard. Again, I don't think that it's significant or determinative of how the Massachusetts statutes work together. The Massachusetts statutes need to be looked and read together for a common purpose in this particular case, and to suggest that the absence of that particular language in the prevailing wage law is somehow significant or determinative in this case would totally negate the entire public policy behind the two statutes. So in that respect, I don't think that the absence of that language, if you accept it, would create an absurd result which would negate the entire statutory scheme, and therefore the absence...
That's a conclusion that may be warranted, but we have to get there. Thank you,
you.
Mr. Ellis.